Hello, good evening, everyone. A very warm welcome to all our attendees and our esteemed speaker. It's been a pleasure to have a diverse and knowledgeable group joining us today for this timely, significant discussion. We are living in the world of digital infrastructure. Is not just enabling innovation, it is an infrastructure of innovation. From powering cloud computing to securing financial transaction, data centers are now invisible engines running our global economy. But with all this progress comes a growing web of legal and regulatory complexity. Data localization, cross border transfer, restrictions, infrastructure liability, breach response, and obligations. The list goes on. That's why today's session is so timely. Today's webinar, organized by WithLaw, that brings together a distinguished panel of legal and industry experts to explore the complex intersection of data, infrastructure, cross-border data flow, compliance obligation, and dispute resolution. Our speaker will share strategic insights and real-world perspective managing legal risk and regulatory challenges in the age of digital infrastructure. Before we dive in, allow me to introduce WithLaw, a full service law firm, excellence in dispute resolution, finance, and emerging technologies. With a strategic footprint in the areas like data governance and compliances, the firm has advised major projects involving cloud infrastructure, AI, and blockchain integration, with contribution to global frameworks like UNESCO, IFSC, and many others. We are also thankful to the supporters of today, that is Digital Infrastructure Provider Association, a collective of technology and infrastructure provider committee, advancing resilient and scalable digital ecosystem. The association plays a vital role in bridging the gap between technologies and innovation, as well as regulatory best practices. Thank you all to all our attendees for joining us today. Your presence reflects a strong interest in navigating the intersection of law and technology. We encourage you a very active participation during this today's session. Please feel free to have your questions in the Q&A, and we'll aim to address as many as possible. Before we begin, a quick note to everyone. Certificate of attendance will be issued to the registered participant who will attend the session for at least 50 minutes, and that will be completely on subject of managed discretion. These certificates will also be accessible by 26th of May. Without further delay, now I have a privilege to introduce our panel for today. We have Mr. Kavan Mankad. He is an Associate Vice President, Legal at Online PSB Loans Limited and Data Privacy Specialist with over 110 years of experience and co-author of a leading Companies Act commentary and an active cybersecurity advocate. We have Ms. Shilpi Mitra. Ms. Shilpi is a technology leader at Microsoft and with nearly 2 decades of experience in building secure, scalable data system, driving Azure data innovation and companion diversity in the tech. Further, we have Mr. Swar Kansagra. He is a policy and regulatory expert with his expertise in data governance, AI, and emerging tech resolutions. Having worked and reviewing on policies for global bodies like IFSCA, UNESCO, SEBI, and European banking authorities. Moving ahead, we have Ms. Manasa Venkatraman. She is a seasoned tech law and policy advisor with over a decade of experience in privacy and AI, formerly leading regulatory strategy at Meta and currently advising the Gen AI and data privacy in India. Further, before any delay, we'll start our webinar and we'll start with Mr. Kavan and we'll have his insights on the webinar.
Hi, good evening, everyone. Hope I'm audible. So I'm sharing my screen. Just do let me know once it is visible.
Yes, it's visible.
Yeah. So data, a new terminology being used, say in last 10 to 15 years. Previously also data was there, but probably we were not that conscious about how the data of ours are being used by majority players. Recently, post 2016, when GDPR come into play, and in 2018, when it effectively implemented, people are realizing that data and its significance, challenges across the data. Suppose your data you see on hoardings on a crossroad near to your home, and you are surprised that, oh, these are my personal photographs on that hoarding. How you feel? Maybe you're worried because someone who is not authorized to access your personal information having so much of your personal information and data. So how this kind of problems arising in our day-to-day life, we are aligning the topic with the real life examples, and we are moving ahead. Primarily data, you consider that as an asset of yours, and you are putting that asset in someone else locker. So you have a gold, you are using bank's locker to store your valuables so that it is more protected under the bank's custody. Data is that asset of yours which you or any person who is authorized to keep your data is storing at someone else's vault, and that vault, like bank, is a data center. It means your data in my house being me a data center. So there are, of course, challenges when you are putting your asset to somebody else's custody. So what are the risks? We are moving into the risk part of putting your asset or your data into somebody else's home. So that is a data center. So the risk part, there are primarily five type of risk associated when we talk about from the company's point of view. One is ownership risk. You have stored your data, and tomorrow somebody says it is not under your ownership in spite of it is your data. That is a risk. Second is compliance risk. Compliance means what exactly you are required to comply, because there are certain provisions which are stringent for X category of a player. There are bit relaxed compliance measure applicable for Y category of players. So that is a compliance risk. If you fail to assess your part under which category you are falling into, there are the risk associated with it. Regulatory risk. There are multiple regulatory frameworks and directions coming in from various authorities like SEBI, Reserve Bank of India. So that is also depending upon the what type of data you are handling and what type of data you are storing with third party. Then financial risk. Of course, there are 250 crore of penalty when we are talking about DPDP Act in India, and GDPR it is almost 20 million euros there. Of course, it is reputational risks, because if I am having custody of your data, then definitely if any breach occurs, I am responsible, my entire reputation will be at stake. Now we are moving into the how we effectively manage those kind of risks through the means that we are having control of. So the foremost thing is the contract. So whatever you want somebody to do it, and if a person is agreeing to that, you are entering into the contract. Let us take an example. You are a company, you are holding voluminous data of say 10 crore individuals, and you are storing that data with X cloud service provider. So as per DPDP Act, you are primarily responsible for managing storing of data. So how you will do that? First is contractual liability. Have appropriate strong language that any breach or any penalty because of the gross negligence or willful default of cloud service provider that is being imposed by regulator on me will have to be compensated by that cloud service provider. Second, vendor risk assessment. If we take a closer look on ISO 27001 27701, a dedicated annual third-party risk assessment (TPRM) process has to be undertaken. So that is also covering the part like how the effectiveness of data breach mechanism will be there. What would be downtime? What would be the uptime? What could be the security measures so far as the data of yours being hosted at cloud service provider. So these are the suggestions. Have a strong contractual language. have right to defense. If your cloud service provider is not of that capable of to invest financial resources, it is your responsibility to step into his shoes, and then you move to the defense part and protect your interest and your data. Shift the burden of penalties. If I am being penalized, you will recover it from that cloud service provider. And suitable exit procedure, because exit is as important as the entry. Now, if we say audit challenges, so what would be the challenges if I am hiring one cloud service provider or data center? One is jurisdiction, because if we select any person beyond the jurisdiction of India, there are challenges, and probably the compliance of cross-border data transfer will be triggered. Second is right to audit. Right to audit means I can go and audit you as and when I required or I deemed appropriate. Third, multi-tenancy model of data center. There are possibility like bank that in the same premises multiple people have their own assets there. So there technically there will be the risk associated with the theft or data breaches because of somebody else lapse. Then resistance to third party auditors. If I select any of the big four to go and audit, definitely there could be the chances of resistance from that cloud service provider or data center. And audit readiness stat. Say if I give them a notice that I want to do that audit of yours and premises, and I'll receive the answer after 6 months, said okay, you do it, the effectiveness of the audit will be definitely being compromised, and I might not be in position to assess what could be the situation and output because of that. Now compliance is, so it is always easy to seek a certifications of 27001 and 27701, because it is a third party audit and it is accreditation to adherence to a particular standard. So any entity having these ISO, you can at least bank on them about they are having advanced level of privacy and security measures implemented. Their physical infrastructure is secured. Second, continuous DPIA. Before doing any change or identifying any sub-processor, data protection impact assessment is very essential. Data localization and data purging undertakings. You should take data localization emphasize. No data of yours should be stored outside of the country, and if that is being stored outside, then appropriate measures should be there. The main challenge with data localization would be if the data is stored outside India, then you will definitely struggling to enforce Indian laws to that particular entity. Data purging undertaking, the moment you stop availing the services, it is the responsibility, contractual responsibility of the service provider to delete all your data. Of course, you will get the right to download the copy, but the data should be purged. Third party compliance audit assistance. If you think a startup is very good in terms of the services, but they are struggling with the compliances, you can hire third party compliance audit assistant for them, and you can mandate that third party to establish a suitable compliance program. Then vendor risk assessment. Periodic vendor risk assessment will give you the edge over what is happening within that service provider. That risk management, that critical status of critical infrastructure would be definitely thing. When there are breach, that report at least will save you that you can demonstrate to the regulator that okay, I have performed all my duties, I have done periodic vendor risk assessment of this vendor, and these are the reports. There are no breaches on my part, I should not be penalized. And many a times in European Union, this argument is considered by the union. Then what are the legal aspects when it comes to the data center SLAs? So the problem would be the lacking of downtime liabilities. If there are breach, they are trying to mitigate the breach, they are trying to resolve the breach, but for 4 days, 5 days, 6 days, your services are not up, and that may create a problem for you. data restoration, within how much time their BCP come into play, and how the disaster recovery and data backup would come into the live mode, so that the other data can be protected from the loss. BCP and DR drills are basically part of ISO 27001 also, and there are separate standard given to BCP and DR drills. This ensures that in case of any adverse implication, within what time a cloud service provider or data center is able to restore your services and prevent your business losses. Incident response. So what are the procedures, what are the policies, manuals of data center in case of handling of incident response? Is there any committees dedicated there, whether they have any support staff for that? So everything would be there. Then uh, nowadays it is a trend that people try to use fancy words in an agreement, which generally starts on best effort basis. Will try to protect your data. So best effort basis, you cannot quantify your best effort. So this kind of words should be avoided when you are drafting SL or when you are reviewing the SLAs. There should be a clear metrics, measurable metrics of that. Then limit of liability. I am complying with all your requirements, and then I say in any case, my liability would be my 6 months of salary or the payment which I am getting from you. So in spite of I am being fined uh, 20 crore, my liability would be 6 lakh or 7 lakh based on the payment I have received. So this kind of terms should not be there in the SLAs. Then the last part is the risk mitigation strategy. We have seen the risk, how we can do it. So first is build resilient legal framework for data governance. Second, multi-track due diligence, do the effective vendor due diligence. Third is legal checkpoints in procurements. So also do legal checkpoint and third party risk assessment from a legal or regulatory or reputational part also. And the last one is regulatory update, uh, contract templates and SLAs based on government's mandate, based on Supreme Court judgment or any other thing. So this is how you can mitigate this kind of risk to the extent possible. Thank you.
Thank you so much, Mr. Kavan. The risk mitigation points were very helpful. Now, I have the privilege of introducing our moderator for today's session, Ms. Rishita. We truly appreciate you joining us today. Ms. Rishita is a senior director at Oracle Health AI, where she leads the transformative efforts in applied AI across the healthcare and life science sector. Her expertise spans platform development, machine learning, and data governance, making her specially suited to guide today's conversation on data integrity and legal framework. Previously, she had held leadership roles at Amazon Web Services, where she contributed to the AI infrastructure behind Amazon Bedrock and Comprehend. With that, I'm delighted to hand over the session to you, Ms. Rishita.
Thank you so much. Very glad to be here amongst all of you, and we have a lot of good experts here on this topic. So I don't want to take away too much time from here. I know the next person here that I would love to introduce and have her speak to you is Mansa. So, Shilpi. So, um, Shilpi, do you want to quickly introduce yourself and then get into your content?
Yes. Hi everyone, I'm Shilpi. I work at Microsoft, and as it happens with Murphy, my machine today is giving me issues in terms of sharing. So I'm sharing an empty screen first, and then let me know if you are able to see my screen. Is my screen visible now?
Yes, it is.
Okay,
Yes.
great. So the way I want to introduce you all to my world is, yes, I'm an engineering leader at Microsoft with 18 plus years of work experience in building different applications in various domains, security, data, enterprise applications, VDI. But what I also love to do is I adore to spend time with my 11-year-old son. We love to travel. I do have interest in dance and craft, and I engage into speaking opportunity like this and at various other forums. So that's my world for all of you here. And without further delay, I want to now take you into the world of uh, how data is there in the cloud infrastructure. We all heard Mr. Kavan explain to us about what is the data and the risk associated with it and some ways to mitigate it. Now, I will give it a spin of what it is to do, take care of data and how the data is in cloud infrastructures. We all know data is everywhere nowadays. You registered for this webinar, your data got persisted somewhere, right? Data is really the new oil. And cloud is transforming how this data is stored and managed by having new structures, new workflows. So understanding the technical nature of this data is very, very essential in identifying how to protect this data and prevent any breaches. Cloud is essentially different services which work on providing works with compute, network, and storage, right? And that's essentially what enables everything that we see. The data in cloud is very, very dynamic. It's very distributed and it's very fragmented. Now, I will slowly try to uncover these for you as I go ahead. So let's first understand what when I'm saying that data is stored in cloud and it is at the very important. So what it is that is stored. We are all seeing various files and videos and audios. All that is unstructured data that is stored as a block storage. It is very useful for unstructured data and provides scalable performance. And all major cloud providers provide storage for all the types that I'll be speaking. So for block storage, you have Azure Block Storage, Amazon S3 is there, Google Storage is there. And then if you want to have really, you will look at the block storage. So I'm sorry, object storage is the one which is the unstructured one which I explained. Block storage is where our disks are there. So when we are having a virtual machine in cloud, that's essentially the block storage that is used. Managed disk, S3, EBS store is there. And then we have our own files, right? I just click a picture that gets stored in OneDrive or on Google Photos. That's just a single file getting stored, right? And it can be accessed across wherever the data is. So these are the three essential formats which are being used. File usually is being used for hierarchical data so that the search is very easy and you can find it. And that's a very, very technical way. But now more important for this topic is what are different security aspects with data. So when we are saying that data is there in cloud and it's moving everywhere, so first level of security we need to provide is in the data transmission. When data is moving, that time it should be secured. When data is at rest, that means data is stored, that time it should be secure. So TLS and SSL is used in for uh, providing the security to encrypt the data in transit, and then the AES and other encryptions are applied on the storage when this data is stored. Now, this makes routing and data access really a little slow, and that's where the data routing and latency becomes an paramount option. So the data is not stored in single region. Today we are having this webinar, but it might be getting supported from various data centers in Asia. Multi-region data transfer is a reality, but it also comes with the latency. So that needs to be handled. So one of the things which happens a lot now is edge computing, where a lot of data is processed at the device to make it closer to the user to reduce the latency. The third part, which is very important, is access control and how you authenticate. Authentication is a little technical jargon, but basically what it means is if it is your data, you should only be able to access. And if you want to share, let's say only one file with me, I should only be able to share access one file. So role-based access, which is RBAC, that is, and then you should be only be allowing authorized access for the data that is needed. And we are all seeing multi-factor authentication, MFA. So most places when we are logging in, we either get an OTP or you are asked to do a verification on your email or your phone. All that are different ways to implement multi-factor authentication. Again, prevents from the data stealth. The last very important part which comes in the data is redundancy and DR. There is auto scaling that happens on cloud, and cloud also does your data replication to other regions to mitigate the risk of data getting lost in case the region goes down or in case a zone goes down. But that again introduces further complication of legal laws and boundaries. For example, GDPR says EU data should only stay in EU. So then the EU data is replicated and backed up only within the data centers in the EU. Now, when all these are the security measures, of course, there are different vulnerabilities that pop up. So if there is not proper access control is put, there's a vulnerability possible that unauthorized access can be done. If your data is not properly encrypted in transition or at rest, then you will be able to seeing data breaches. And there have been many real world examples where data breach happened and there were serious implications of that on different companies. And then if the data is lost due to region issues or something, you can face data loss. But there are laws against prevention for it. And I'm just going to list them here, but not go into the detail because my friends here are much more capable and experts in this. So ISO, NICT, FedRAMP are some of these which are in particular data protection standards. Now, when we are seeing that the data is how it is stored and what all can be the security risk, next, I want to take a little bit time to see how you classify data. So there are at a high level, we can look at the data classification, sensitive data and non-sensitive data, confidential data, public data. So any organization's intellectual property, trade secrets are all confidential data, whereas marketing material, press releases, public documents, those are all public classified data. And then your personal information, your SPII, which is your sensitive your personal information, your sensitive personal information, your health records, all those come under the sensitive data. So what happens is there are different classifications that are given. Some of it is, so other than PII, SPII, there is organizationally identifiable information, which is OII. There is protected health information, PHI, and you have payment card information, that's PCI. So there are different classification that is done. Each organization is required to classify the data as soon as the data is stored. Now, what are some of the challenges when you need to classify the data accordingly? So when you are trying to classify the data, very first issue that comes is manual classification. Someone can misinterpret and put the wrong classification, ending into mislabeling. Because data is siloed into different places, it is fragmented. Classifying the data could be inconsistent or become difficult. And data storage cost is very high. So that might become a concern. And eventually, you still have a concern of security of data breach or data loss from either insider threats or accidental exposure. So all that is very important to be prevented. And the biggest part is any organization, when they are taking the data and storing it, PII, OII, all these are not stored within the company. So all those are then covered very briefly multi-tenant. So it's on the customer's tenant is where that data resides in terms of cloud infrastructure, if we see. Now, we are looking at different data, right? But what is happening really with the data? Data is created. So at the time of creation, there is a consent taken that I'm going to store this data and I'm going to be storing it and using it for XYZ purpose. And after storing and processing it, data is archived for certain duration. And then eventually the data is destructed because you cannot really have the data lying with you on the permanent basis. So what is the best practice to do is you try to do automatic classification, do data encryption every time, and define and implement really clear retention policies to prevent against data in terms of the life cycle breach. These are some of the standards which are applicable in terms of the, again, data in life cycle and protection. Now, some of the legal risk associated with data Kavan covered. So I'll very quickly touch upon some of these. Okay, I'll just take one more minute. So in terms of the legal risk, all these data breach, contractual, regulatory issues, ownership and privacy issues are there, which Mr. Kavan covered. But the best practices to cover for to protect yourself for them is go for the compliance programs and review the contracts, and then also take cybersecurity measures very, very seriously. Remember, protecting the data, protecting the data is the key to mitigate the risk. And lastly, I want to cover one quick point in terms of the data infrastructure. Reliance on the infrastructure is the biggest issue right now, which is coming in the picture, because if the data is not available, there is a severe penalty which is applied, and that's a very, very big loss. So we need to protect against cross-border data and infrastructure reliance and all, but environmental concern is also very sustained there, because the larger amount of data that is running is again putting load on the environment. So very quickly touching upon, these are some of the real world examples of data loss. Yahoo had a data breach which costed a lot in terms of their evaluation and the lawsuit. SolarWinds supply chain attack happened, and Marriott International data breach happened. So protect your data, store it properly, understand the data flow and data structure, and then apply the effective strategies in terms of doing the proper classification and mitigating the breach. Thank you.
Thank you so much, Shilpi. I think that will be very useful for everyone to have the basic concepts in place from everything that Kavan and you shared. Next, I would like to have Swar go with his presentation. And Swar, if you can also start by a little quick introduction in your own words.
Thank you, Rishita, for handing over the mic to me. A lot of insightful discussions going on with my colleagues. So, hello everyone. This is Swar Kansagra. I am co-founder of the law firm with Law, and I personally work on international policies where till now I have worked on frameworks proposed by various international organizations. I have also worked for the financial standards that are being developed by non-profit organizations, AI frameworks. Also have worked in the GIFT City IFSCA, that is being one of the prominent coming up initiatives by government of Gujarat. This is something about what I do. Coming to the topic, yes, there are various challenges or the coming strategies that as an in-house counsel, my colleague Kavan has covered. Moving forward, Silpi has also talked about how our data can be fragmented. So now, since we know all these things, I think it's very much important as in how the governments around the globe are looking at such kind of scenarios, or how they are trying to curb the transfer of data between the countries. So that's where I think the data sovereignty or the transformation comes into picture. You'll be amazed to note the statistics. Every day, 328 million terabytes of data is created. Now, this is something which is a big figure, and Silpi can understand the quantum of what I'm talking about. And so this is not something which is limited to a particular country. It is being developed and it is being transferred between the countries, especially with the development of AI, where AI is being trained in some country and the solutions are being developed in some other country. So these are some of the challenges, and how the governments are looking at it. So one of the cases is US Cloud Act, where the government needs the specific company to declare the source of data and where they are storing it. And again, the EU's screams too, where the EU US privacy concerns are there. And of course, the most stringent one, data security law by China, where they specifically focus on or the restrictions on the transfer of data outside China. So these are some of the cases. Now let's understand how three important questions. The first is access. Who can lawfully retrieve data? Now, since we know how to handle the data, what are the types of data, how to retrieve it? Second is sovereignty. Whose laws govern cross-border data flows? So this is some of the important challenges that each and every government is facing today. And I'm sure we will have some fruitful solutions in future. And the third one is protection. What are the legal duties to secure data? As in some of the strategies are covered by my co-colleagues. Next, please. So just touching upon the statistics, global market in 2023 was 200 billion. Can you understand the global market of data centers, and which is projected to be $500 billion by 2030? Now, India alone is about $10 billion. So this is something which is, we are one of the biggest data producers, and where we have a good pace of development when it comes to data centers. Capacity in India, it's 950 megawatt in 2024, which is projected to be increased by 1800 megawatt in 2026. Energy consumptions in US data center use 4% of total energy. Now, 4% is a very big figure when it comes to a whole country or a world perspective. Expected to rise by 9%. This is something which we need to understand, as in sustainability and data centers are supposed to go hand in hand. Now, what leading regions? I mean, so this is where we are one of the cutting edge. One is North America, of course, and the second is Asia Pacific, where one of the prominent country is India, as and we. So in India, various countries or various cities have been dominating. Let's focus on what are the different acts that we have. The first is Digital Personal Data Protection Act, which is enacted in 2023, which focuses on regulating processing of personal data, talks about cross-border data transfers. It also establishes the Data Protection Board for Dispute Resolution. Now, this is something which the companies have been waiting for such kind of an enactment. Now, penalties up to rupees 50 crores for non-compliance. Now, this is something which is we need to understand. The government is now coming up with stringent penalties for non-compliance when it comes to data. The second act that we focus is on Telecommunication Act. Of course, directly this is not something which regularizes, but the infrastructure or the network that we use for data is something which is covered by Telecommunication Act. What are the challenges? No defined list of adequate countries for data transfer. Now, what country should come in? As China has predominantly concluded that no data should go outside China, compared to the confidentiality and the level at which the data is being processed. Unclear criteria for adequacy assessment. How an assessment should be. So each and every company, as Kavan rightly mentioned, has created their own framework from the experience that we had. With statutorily, we have some frameworks, but still they lack adequacy. And the third is possible conflict with global trade and data sharing agreements. Now we are living in an era where AI is booming, and one of the challenges that we face today is how data sharing should be, whether it should be with respect to the data that is being processed by AI or how it should be. That's something which each and every government is thinking on. Data protection enforcement in multi-jurisdictional systems. So the regulatory body, as I said, is DPBI, which is enacted under DPDP Act. The second is international cooperation, which is critical for enforcing bylaws. If each and every country goes on doing as in the data is ours and we cannot let it go, or go to other countries. Since the data is being processed by AI, it's an international issue. So a country limiting itself to the data is something which at an international level is need to be thought of. This is something, and the challenges that we face today is variations in data protection laws. We have different structures in Europe, for example, EU AI Act, which also touches upon on the processing of data. It talks about how the data is being processed. It depends. It has a three different layers as in how data can be processed depending on how you are using it. If it's more confidential, there are more strict norms. If you're not, the compliances are less. So this is some of the role of DPBI to have the adjudication of data protection or data breaches cases. Some of the key data disputes that can be referred to DPBI are data breaches and unauthorized access, non-compliance with protection laws, ownership and IP rights, of course. Next, please. Recent regulatory development. Now in California, legislation for energy use transition, transparency and efficiency standards in data centers. As I mentioned earlier, sustainability and data centers go hand in hand. So that's what we are seeing right now. California is doing in that direction. Introduction of Sustainable Data Centers Act, limiting new constructions and mandating renewable energy use. As we have mentioned, this is one of the important part when it comes to energy consumption. In India, DPDP Act is already formed. We have the National Data Center Policies, which focuses on rupees 3 lakh crore, which equals to $36.5 billion investment in the data center ecosystem over the next 5 years. Recently, government has also introduced the 10,000 GPU plan to introduce this infrastructure will be developed by, or it is being developed by Government of India, where it increased to 18,000 GPUs. This is a prominent step by Government of India for its startup ecosystem. Tax rebates, electricity waivers, these are some of the incentives that India is focusing on for data centers. RBI's cloud initiative, pilot project in 2025 for affordable local cloud data storage for financial firms. So this is how you can see how government are looking at when it comes to different scenarios and how they are looking at for incentivizing cloud centers or the data centers. Next, please. These are some of the important cases that we have. One of them is XAI, which is Elon Musk's AI company, operates 35 gas turbines without necessary air pollution permits. So this data centers in Memphis was breaching the law, and of course, he has to face the consequences. The second one is the breach of very personal and medical data, and that's why Star Health sued Zengen. This is one of the important aspect. The case is, I think, pending. The third is Samsung accused Competition Council of India or Competition Commission of India, which unlawfully detained employees for seizing data during an antitrust probe. This is some of the case studies. Next, please. So access, sovereignty, and protection. These are some of the important aspects that we need to think on. Who can lawfully retrieve various jurisdiction, e.g. Cloud Act, companies must log reviews, sovereignty, data localization laws, jurisdiction conflicts, and in terms of protection, we have different bylaws, fines up to 250 crores in India. Next, please. Future outlook. No, so when it comes to how we should focus on, so we need to build secure, sustainable, and compliant infrastructure. Work proactively with regulators. Don't wait for enforcement, as Mr. Kavan said. The company is already doing it. Leverage India's momentum for favorable policies and investment, global data leadership. Use frameworks like DPBI for not just for compliance but for strategic advantage. This is something which everyone needs to have and to do to have and challenges to focus on data protection. Next, please. Thank you. That's what it is. In short, you need to understand how an international policies are going on. The much needed thing that we need to do right now is to international collaboration between the countries for the data protection. Thank you.
Thank you so much, Swar. This was very interesting to hear, especially around these important open questions around how cross-border jurisdiction and such would work. I'd love for Mansa to continue from here. I know she has experience in around these areas as well. Mansa, if you can start with a quick introduction of yourself and then get into yours.
Superb. Thanks so much, Rishta. And it's very hard to follow Kavan, Shilpi, and Swar's excellent presentations. I can only hope that what I will speak to will hold a candle, at least to what you folks have presented. I also took the lazy route today. I don't have a presentation, but in my introductory remarks, I just wanted to focus on two or three high-level themes. Um, Before I get into it, like Rishita offered, just a brief background about me. My name is Manasa, and I am a privacy and data lawyer and also a public policy person. The best part of my career has been in public policies. And so I thought today, for when we are discussing data centers, data infrastructure, and data as a whole, sort of unpacking it, it might be useful to start with the 36,000 feet view of what the Indian government thinks about data infrastructure and where it's going. Um, so let's go back 6 or 7 years, around 2018, 2019, when India was still very much in the process of discussing, debating, redebating what our privacy law should look like. For those of us who were close to that discussion, you'll remember that data localization was a theme that kept coming up. And Swar and Shilpi have also sort of alluded to that in their presentations. But if we had spoken about data centers back then, it would have more or less been in the background of, against the background of discussing data localization. And that's because the Indian government at that point, MeitY viewed data localization or data centers in India as the shortest and the most efficient way to get access to data about Indians or India generated data for assorted purposes to safeguard data of Indians from foreign surveillance or cybersecurity vulnerabilities that happen when data transits through subsea cables or optic fiber networks. And the third big motivation for localization, and I promise you this will make sense in a couple of minutes, is the immense economic value that can be generated from harnessing raw, unstructured data that Shilpi also threw some color on, sorry. However, the DPDP law that we have landed up with does not mandate data storage or data localization at all. And it's a sea change from where the MeitY was 6 years ago to where it's landed up with the privacy law. We're not out of the woods yet because the draft privacy rules still throw a spanner in the mix, and they still sort of say that data transfers are okay, but they can be restricted at any point in the future by the government, by an order of the government, which sort of re-emerges a lot of uncertainty and unpredictability that businesses grappled with. We'll come back to that in a minute, but I want to talk about the evolution of dialogue around data centers from 2018 or pre-2022 to now. Today, when we speak about data centers, the types of conversations that I see the government willing to have or public policy stakeholders willing to have is a lot more sophisticated, and it's moved forward significantly from the defensive protectionist data localization background we were speaking in. Today, and this is in a huge way thanks to the way in which AI has taken the world by storm, especially post DeepSeek. It deeply resonated with India that we can definitely build compute power. We can build data infrastructure here And it's a question perhaps of how do we do that, not whether we can do it. And that moved the needle significantly in policy conversations. What also helped a lot is legal certainty, regulatory certainty. Just having a privacy law in India gave businesses a lot of confidence in sort of thinking about next steps. I can share an example. Several American big tech companies that were in India or that have been operating in India for decades now had significant challenges working through data localization sort of scenarios. Um, However, post the DPDP law, there is a lot more forward-looking conversations that they're now getting into. Meta, for instance, had undertaken thinking about and setting up a data center in Chennai, in India, back in 2024, last year, and this is a marked change from where Meta was a few years ago. Moving quickly on, when we speak about data regulation, data management, building resilience into contracts, another theme that we need to keep in mind is the theme of tech sovereignty or data sovereignty. Um, in conversations with the public policy ecosystem, with regulators, this theme often comes up, and it feels like the Indian regulator deeply cares about how India can demonstrate its sovereignty over data, over the digital landscape, how that can manifest in very, very tangible ways, and how that can set us apart on the global stage. India would love to leapfrog into technological innovation and establish itself on the global stage alongside powerful international peers like the US or China. What would it take to get there? How should India have its own unique spin on all matters data regulation? When we look at the Digital Personal Data Protection Act, it's not in any way similar to the GDPR. It is unlike most global privacy laws, and this was very intentional. What's also intentional is how India is thinking about um, regulating artificial intelligence or the role that regulation will play for artificial intelligence. One of the key pillars of the India AI mission, and this is a very critical mission because following from a huge AI Action Summit in France last year, the baton has been handed over to India. So India will hold presidency over the AI Impact Summit next. And so it's framed an AI mission. One of the pillars of that is building compute power, building infrastructure resilience. And that's where a lot of the larger umbrella under which a lot of conversation around data management and data centers resides in. These are critical because they sort of help us think about how we should structure different levels of contractual or liability in contracts or SOPs or other mechanisms, say even for data flows. I also had a couple of points with respect to data in transit and cross-border access to data, but perhaps a better jump-off point to get into those weeds, Rishita, is when we get to the panel questions.
Yeah. Sounds great. Actually, a lot of what all of you said have been, giving me. So, for everybody's background, I am on the receiving end of a lot of this. So, I am a practitioner and a researcher in the modeling space with AI. I have been for the last 10 years, and so I've seen it from before it became such a big, I guess, a little bit of a hyped deal. And there are, as all of you rightly pointed out, a lot of new things that are coming up now. So from a practitioner's point of view, we think of these as very important aspects that the system around us can help us deal with. And I think it's becoming very clear that every country is going to, or every region, like say EU with GDPR and others, are going to have a take on how to go about this from a regulatory and compliance point of view. So, um, would love for all of you to join me on camera, and then we can get into some questions. I think a lot of what all of you said has been making me think that um, India is at a bit of a critical juncture in where we can be on this thing. AI as a whole is coming through. So there are a lot of points that are beginning to look like they are getting to the right side. You have new acts coming up like DPDP. You have a lot of other energy going around, new missions like India AI, bringing new compute here, the life cycle aspects and SLAs and how there are some loopholes here and there. So with all of that in mind, I have a few questions. What we'll do for the next round, the format for the next few minutes is we'll do one question. I'll try and pick two of you for that question, and then after one question from me, we'll do one audience question. So um, Saloni, if you can help me monitor the audience question queue, then after this, we'll go to one question. From there, we'll come back one for the panel question. So the first one I have is regarding compliance and sovereignty and the push and pull of that. So Swar and Mansa, you both kind of pointed out that as these new things are emerging, I was noticing that there's a bit of a tug of war between global data access, like the Cloud Act, and the Indian sovereignty coming up, compute power, and all of that in discussion. And in a hypothetical breach in such a situation, let's say there's a foreign cloud provider involved, but it is, let's say, something like Indian health records or something like this. Um, who governs, who decides, and is there an ideal adjudication model? Is there something in the acts that can be kind of read in a certain way? Why don't we start with you, Swar, and then Mansa, if you can follow up.
Great. So it's a very important concern that each and every data intensive company is facing today. Uh, in fact, we are one of the most affected countries with this problem, as we being one of the biggest data producers and data being transferred outside our country. So this is one of the challenges. Now, how to adjudicate this particular issue depends on various things. The first thing that we need to consider is the contracts between the parties. This is the first thing that we need to consider. Second, whether that contract talks about arbitration. If there's an arbitration, there's an easier route, and then you can have the end of arbitration. That's something which is a talk of dispute resolution. If there's no arbitration, then of course, if there's an exclusive jurisdiction which is being accepted by both the parties, then in that particular jurisdiction, that suit can be filed. This is with respect to the dispute resolution. Now, when we talk about such kind of problems, we need to understand that the data that is being processed is something which is complying by the local data laws. Now, we already know that we are using various AI tools. For example, the moment we use ChatGPT, we are liable by US laws. So the moment we are using the services of foreign companies, even though we have domestic bylaws, we are levied upon by foreign laws, which each and every individual users need to understand. Of course, when it comes to companies, they already know about it. But such kind of a transfer at a global level, as I mentioned in my presentation, is very critical, as in each and every country is talking about their own data sovereignty. So EU is very stringent, China is very stringent. India is copying up in this journey as in half because we are a democracy. Our way of working is a little bit different from other countries. We are more of an open country where we also believe Vasudhaiva Kutumbakam. So this has some of the challenges to the data sovereignty, or I would say data ownership, that is coming in a way in our approach towards how a black and white strategy should be. I think from here Mansa can take forward.
Yeah. Would
That
love to
make
hear
that
your
makes
views and also the subjectivity involved. Yeah, go for it.
No, absolutely. That makes a lot of sense. The two aspects from your question that I want to pick on, Rishita, are what do you do in the event of a breach, and how do you resolve the conflict of law situation or the multiple jurisdiction situation? So, in the event of a breach, unfortunately, Indian law is far more rigorous than many other personal data protection laws across the world. And now, with the DPDP Act, once it kicks into effect, you will have multiple people that you need to notify of a data breach. Whether or not it's a foreign company that's storing data in an Indian data center, breach requirements in India will apply to you. So just to recap very quickly, within 6 hours of the breach, you need to notify the CERT-in, which is the emergency response team. And there's several categories of information that you need to communicate to them. If the DPDP Act goes into effect in its current form, with the rules going into effect in its current form, and the rules were in their draft state, so they're very much being discussed within the MeitY, then you need to notify the Data Protection Board as soon as possible. And within 72 hours, if I'm not wrong, at the latest. And you also need to notify all the people that were impacted by the breach. We're hoping there are thresholds. Breaches above a certain that affect above a certain number of people are ones that need these sort of bombshell notifications. Because there's also categories of data breach, and there's different speeds at which you can plug the breach. So that's just a very, very summary recap of what one would need to do if there's a data breach. But to your other interesting question about multiple jurisdictions, this takes me back to localization debates once again. At the time, the ask to set up data centers in India or to store data in India was that, tomorrow if the Indian law enforcement needs to access data, personal data for an investigation, then they can just walk over to the data center, ask them to open up some lockers and have access to that personal data. But that's not quite how it works. A foreign company, let me just take an American tech company because that's the conflict that I'm closest to. An American company that's storing data in India will not be able to hand it over to Indian law enforcement very quickly, because you will still have to follow a long-winded international route to access this data. And this is a very interesting cross-jurisdictional data access mechanism that is broken in many ways. It's called the MLAT, or Mutual Legal Assistance Treaty. India has entered into an MLAT with about 44 countries. And an MLAT, sort of trying to access data in another country via an MLAT, will take you a short 12 to 18 months of time. And so it's not a mechanism that we use often because it's so time consuming. It is very bureaucratic. An interesting solution has emerged from the US, incidentally, called executive agreements under the Cloud Act. And I know Swar touched upon this in his presentation. The Cloud Act basically short circuits the entire MLAT process. It says that law enforcement in the US can access data in India and vice versa if US and India enter into a Cloud Act agreement. Sounds neat enough. But to enter into this agreement, a US domestic authority, I forget whether it's the Department of Justice or a court of law in the United States, has to deem India adequate or sufficiently compliant with the rule of law or having adequate privacy protections. Um, because of sort of several reasons like this that don't quite align with the way India does foreign policy or India does international agreements, we haven't yet signed an agreement with the US under the Cloud Act or any equivalent bilateral agreement. Long story short, the point that I want to make is that multi-jurisdictional conflicts will still be very real. And the solution to that is government to government, easing up government to government data access protocols. That's a very, very active debate going on right now. And with the front foot that India wants to have on building digital capability infrastructure, it's a good opportunity for us to present a solution.
Yeah, from what both of you said, it sounds to me like this is a great opportunity, as well as like now is the time to act on it if we want to before it becomes a bit of a threat, right? Because it sounds like there are some long bureaucratic processes, and there is like time, and there's a bit of a time sensitive thing around how we plan this. Should we tighten it, or maybe we use the first few examples in which this happens to tighten it? But very interesting to hear about the differences across the globe and how they'll be enacted, and the time ranges for something like MLAT, which otherwise I just would have made sense of it as conceptually that makes sense, like that's what you would go for. So very telling. This kind of makes me think and brings me to my next question. Originally, I had thought of the question based on the fact that Shilpi covered a lot of the life cycle concepts and details, and Kavan, you covered a bunch around, um, you know, specifics around SLAs and how to tighten them. But even flowing from this current question, it sounds to me like every sector is going to have different levels of sensitivity. Like, for example, if you're in an entertainment sector type thing, you could maybe sustain a little bit more of, like breaches and who sues you, and in turn, who do you sue, and all of that. While, let's say, if you're in health records or in other forms of finance, there may be a different level of sensitivity. And coming from this perspective, starting with Kavan first and then Shilpi, I would love to hear your thoughts on, do sector-wise contracts and SLAs make sense? Is there precedence of this around the world? And like, given that India is reorienting towards kind of enabling AI through infrastructure growth, how should we think of this in maybe taking leadership in sector-wise contracts in this space? Kavan, if you'd like to go first.
Yeah, Rishita. So basically, in a legal drafting word, we what we used to see and we used to follow is we are having one master agreement, which is covering all the traditional clauses, which are almost same across the sectors. Then we narrowed down to a specific requirement. Say if I am doing a contract, or if I'm a company who is more towards health records, I'll try to bring the as sensitive personal information kind of the clauses and restrictions to that. If I'm handling the data, but I am not using any personal information, the clauses in the letter would be less stringent. Of course, it will have that confidentiality part, and that limit of liability, indemnity, and all clauses would be there. But generally, SLAs are more technical from the standard contract part format. So SLAs generally, if we say the IT sector, there are various regulations dealing with the same. Say if I take a regulated sector like RBI, RBI is very beautifully drafted policies and framework guideline applicable to the banks. That is outsourcing guidelines, it's outsourcing of IT services and outsourcing of financial services. Both of these takes care about what should a bank do when they are executing an agreement. What should be the standard clauses? If we take insurance sector, there are pretty much guidelines of IRDA, that what should be the tentative clauses, how the health records or insured details to be protected. So all of this is already being taken care while we break into the sector. But the crux primarily remains the same, that confidentiality, availability of the data, and privacy and security of the data. And of course, as now India moved to the hefty fines, like up to 250 CR. So that is something also very important to learn, that how you shift the burden of yourself on the other. If you are entering into the processor to sub processor segment and sub processor segment, how the delegation or subcontracting will work. That is something a sector needs to think of it.
So I guess, before we move on to Shilpi, so Kavan, from what you're saying, I'm hearing that in a way the layered approach is helping, that because sector wise there are already some independent contractual requirements and guidelines and regulations that would help, but I guess like it has to boil down and pull into some such core technology or core data center data protection related this thing that makes sense. Shilpi, your thoughts?
Yeah, thanks, Rishita. So as I think Kavan covered the contractual part, I want to touch a little bit on the SLA part. Sector-specific SLAs are the reality, and it is going to become more and more prominent to follow with the advent of AI that is entering in each sector, right? So let's say if we are into the health sector, and there is an organization, a healthcare organization, which is using a particular cloud infrastructure. Uh, for them, the SLA of the data or the service not being there up is very, very high. So it goes, the SLAs goes 99.99, right? Whereas if it is in the entertainment sector, the SLAs then change. SLA goes into 98, 99. It is into very small point difference, but that makes a huge difference in terms of how the whole contract works. Now, when the AI is entering into this whole aspect in each of our lives, in each sector, what these SLAs will also start defining is not just the uptime or the service that should be there, but also the accuracy. So if let's say there is a AI model that is created to detect a particular disease, the accuracy threshold SLA for that would be very, very different from the AI models that is generated to recommend the next list of movies that you can watch. So basically, based on the segment and the sector that we are in, there's a huge difference in the SLAs. If we are in a bank, just imagine you're in the bank. Nowadays, a lot of banks are using cloud infrastructure, right? And you are at the teller and getting the work done, and then the teller says, sorry, my computer, I cannot work, the service is down. How frustrating that could be now. It was probably 20 years ago. We have all faced it, but I don't think anyone is expecting to do that now. People are now handling the bank on the mobile, right? So the uptime for any banking application in the finance sector is much, much high. Just imagine if the Paytm or Google Pay goes down, even for a half an hour. In a city like Bangalore, where everything is cashless, I cannot even go on an auto ride. So the SLAs in the sector based and with the mix of AI are going to be, I think, the differentiator that will come in the contracts now.
Yeah, this is so interesting to hear, because I think rightly as you said, each sector, like in some cases it just causes annoyance to the end user, which is huge, but like somebody can maybe just say something like that, versus even in the US in health, like you said, like we would have an SLA where if one system goes down, you have to have like a few hours in which it should propagate all the way through and back to make sure that
Yeah.
care decisions and other such things are being handled in alternate modes, versus let's say your Uber app goes down, like yes, you get stuck and you get delayed,
Yeah.
but that's very different. So very useful to hear. I see that we have a lot of good questions from the audience as well, so I'd love for us to move there. Most of them have already asked it to specific people, so I'll start with the first one. I think Swar and Shilpi, this one's for you from Parth Chatrala. How do you address legal disputes related to data from small companies in India, since they cannot afford to reach out to US jurisdiction due to cost and other such implications? And I do want to go through more, so I would request both of you to try and maybe keep us to a couple minutes on this one, and then we'll keep chugging. Shilpi, do you want to go first?
Sure. I think one of the first thing that is protecting us is the DPDP Act that has come, right? So that provides a very clear, defined law, which then US organizations do acknowledge and act swiftly. But other than that, there are intermediaries which can be contacted, and there is also an online dispute resolution way that can be followed. So that's what I will recommend for the smaller organizations.
So I think what we need to do is the language of agreements are very much important. So when we talk about a small scale companies in this era of ChatGPT, everything is possible. They can have a robust language of their agreement. Now, when it comes to a specific jurisdiction, now when we talk about a small company talking about the specific jurisdiction, this is a black and white hard truth. There is no option for them. See, for an example, if any of the AI development company is using ChatGPT model to develop their further solutions, then they are bound by the terms and conditions of ChatGPT. Now, there's no going out of this loop. But what they can do is they need to make sure that their own infrastructure is complying with the jurisdiction of the solutions on which they are providing their services. So if a company is developing a software on ChatGPT, they need to do it based on the US as well and as well as India as well. This is something is very much important when a small scale company is thinking about developing AI solutions or handling data.
Yeah, that's definitely interesting. And in terms of what you said around Chat GPT's contractual agreement, you're already going after, so you kind of have to have a path through it. I saw parts that you had your hand raised. Sorry, I want to make sure that you are able to give your counter question as well. Can we have his mic on, Saloni? Is that possible? Um, are you able to unmute yourself, Parth?
I think now he can.
Now you can. Okay. So
Uh,
Parth, you can try to unmute yourself.
Yes, yes. Hi, hi. Good evening. I hope I'm audible.
Yes, you are.
Hi. So, thanks Shilpi for throwing light on that online dispute resolution. Would love to hear more on that. However, still, I have one small question for Swar. Actually, the thing is, this Microsoft Azure and Amazon AWS and all these companies, they have their TOUs, terms of use, which basically are not editable. We have to just agree to that. And as per the TOU of Azure, Shilpi, I think you must be knowing of this also, that the default jurisdiction is Washington. So for small companies, say for example, so relatively so I come from a IT company in Ahmedabad. I work as a legal team member, and we are a relatively small company, so we agree Washington's jurisdiction. God forbid, no dispute has arisen till now. But as per the TOU, we would have to reach out to Washington's court, right? So in that case, just wanted to know from Swara also, like, what can we do? I mean, I don't know. God forbid, tomorrow something happens, we will have to fly down to Washington to appear before the courts, or at least we have to hire some lawyers there. It is a costly affair. But I mean, it's not practical for small companies to do that and resolve the disputes. Even we do because there is no scope for having clauses in the agreement which provides another alternative way of resolving the disputes, as you said.
Great. So I think this is being projected to me. So I believe, see, this is one of the negative aspect or the blackout part of the companies or the IT giants, whether it's in Meta or it's ChatGPT, OpenAI, or any other big company. They have the market dominance, and then they force you to have an exclusive jurisdictions of their local country. Now, one of the ways to find out is bilateral treaties between the countries, and that's where the data sovereignty comes into picture. Whether is there any bilateral treaty? This is point number one. Point number two, in case of dispute, our DPDP Act, as Mansa always also said, that these are some of the good DP data protection laws. We need to figure it out how to handle such kind of an issues with respect to Indian jurisdictions. Practically, as of now, I believe this is one of the biggest challenges that the IT industry is facing. And the same problem goes with the language as well. Now, when you ask Chat GPT, it always interprets in English language. Now, we belong to a country where there are different languages in different states. So that's why we have this model of Bhashini, which is being developed by Government of India to handle the problem of language that is being processed. Now, in that also, there's a problem because each and every time you develop a software, that software will be on the English language initially when you are using US companies. So coming to your question, when it comes to disputes, as of now, in case of bilateral treaty, there is an option that we can go forward with a local bylaws. But if there's no cooperation between two countries, then there's no option. You have to run foot and toes between the two countries. That's the only problem that we have right now.
Yeah, noted, noted. So that works. We will keep in mind the alternate option. Luckily, nothing has come up till now, but we will surely have a look at it so that if tomorrow something comes up, we are ready with this alternate thing of going by way of bilateral treaties. Just now, so since now Saloni has unmuted me, I just wanted to reach out to Kavan Bhai as well. Kavan Bhai, good evening. How are you?
Um, Parth, can I have you go after a round of questions from everyone so that
Okay.
we hear from a few more people, if you don't mind?
Yeah, sure. So in fact, next question was my only. It was addressed to Kawan. So I
I
thought
know,
that
I
now
know,
that I'm unmuted, yeah.
I know. I
No
appreciate it.
problem.
And
No problem.
I just meant that I wanted to get like some people covered and come back to you. I do want to, let Kavan answer, of
No
course,
problem.
that he's doing well and here as
Sure,
well. Yeah.
sure. Fair enough.
Thank you so much.
Yeah. No problem.
So the next question is from Vimal for Kavan as well. He's wondering if you can share examples of legal risks stemming from unclear responsibilities between enterprises and infrastructure providers. And yeah, actually, Kavan, why don't you go for it and then we'll come back.
Yeah, see, when we are seeing a risk, we generally do not see risk from only legal side. We evaluate risk from an enterprise level. See, I'm handling risk part of my company, and I cannot say that only legal risk arising out of the contract or poor drafting should address. As a legal or risk professional, it is our responsibility to have a holistic view. So I'll give you briefly examples of what could be the problem. Say, uh, if we take digital data, Indian DPDP Act, it nowhere specify any liability of data processor. Everything is a per data fiduciary or data fiduciary, a significant data fiduciary is responsible and not the data processor. Now, what will happen? You have poorly drafted your agreement. You have not shifted the burden of a non-compliance or indemnity part is not there in that agreement. And if regulator and if data breaches at your sub-processor's end, inquiry happens. And if there are fines on you because you are primarily responsible, you cannot go after your infrastructure provider to recover that penalty. Agreement generally refers to the thing or understanding in writing which otherwise is not forbidden by law. If I am agreeing to something and you are acknowledging that you are also agreeing to that part, and if it is not ultra vast to any law, it is not unconstitutional, it is as simple as that. If I say up to 500 crores of penalty if I pay because of your negligence, and you will give reimbursement of 1000 cr to me, and if you are agreeing to that, then Indian laws, Indian Contract Act requires that 1000 crore to be paid to me. Second example, so let's take example of breach notification. You are being a data fiduciary and you have not specifically categorized roles and responsibility. The primary responsibility of breach notification will be on you and not on your sub data processor or infrastructure provider. But what happened? Your infrastructure provider never informed you about that breach. there are incidents, they evaluate internally and they close it. You are not aware about that, and after 3 months, 4 months in dark web, somebody find their data available. So, and then you are getting sued, and then you came to know, oh, means how that happened. Nobody informed me. My infrastructure provider never consulted me for that. So this kind of illustration on brief would come into play. Generally, what happens? Drafting happens on standard template and based on the understanding between you and your infra player. But the one instance, one loophole will wipe out everything. We have seen many companies closed and went into the liquidation because of they were unable to pay regulatory fines. So these are the examples of the unclear responsibilities between enterprise and infrastructure provider, and that is not restricted to infrastructure provider. Basically, from every vendor point of view, this will be the common risk available.
Thank you so much, Kavan. I think this is very useful. I want to keep us moving so that, we kind of go through more questions. Um, Maybe Abhishek, I think your question, Shilpi has been very kind enough to answer in chat. So we can come back if you have a counter question after the next one. The next one is from Yash for Mansa, and he was asking that given current trends, what future jurisdictional or ethical tensions do you foresee in the personal data processing landscape?
Great question. Since we're short on time, I will just answer this very, very summarily. The lack of interoperability or frameworks for interoperability between the DPDPA and established privacy regulations worldwide or data regulations worldwide. We don't have an adequacy system built into our privacy law. And we don't know if India will sign on to the CBPRs or other sort of international mechanisms that are already in place. So the lack of visibility on how the Indian law will match up to its global peers, the lack of predictability. There is about 26 provisions in the DPDP Act which have which state that these will be decided by the government through regulations or an executive order at a future date. This is great because it offloads a lot from the statute, from the text of the law, keeps it flexible, but it causes significant unpredictability for businesses. And so you want to sort of build a certain routine, a certain certainty into the law, and that's missing. And that is something that I see sort of holding us back significantly. The third is something that it's a substantive thing. It's not a process or a thematic thing. But how will the Indian law, the data regulation, align with other Indian technological regulations like the Copyright Act when it comes to something like web scraping or accessing publicly available data for AI purposes or for larger larger goals, and how will our data infrastructure live up to that? I will pause there.
Makes a lot of sense. By the way, for both Yash and Vimal, if you have things that you would like to comment on for Mansa and Kavan back, feel free to use the chat again. And Kavan and Mansa, if you can see there. And then I think we have one from Maulik where this is for Swar. How are courts and regulators responding to emerging litigation involving data centers as focal points of sovereignty disputes?
I believe, see, courts are bound by law. So we are talking about bylaws, and so as we discussed, we have DPDP law, we have also IT rules, and now we have CERT as well, which focusing on how the disputes should be handled. Now, fortunately or unfortunately, we are living in a country where the constitution is being developed, taking from the best parts around the globe. So when it comes to interpretation of law, courts finds it little challenging when it comes to litigations with respect to data centers. Our constitution particularly touches upon this aspect as in constitutional grounds, which is Article 19 and Article 21, where Supreme Court's privacy jurisprudence is something which we need to consider. We also, as in the courts of India, needs to consider the mutual legal assistance treaties, as I mentioned with Mr. Parth's query. And Niti Aayog, of course, talking about various data centers, the Competition Commission of India. These are some of the key aspects which our judicial bodies are touching upon, and they are focusing on how such kind of an disputes can be handled with the existing bylaws.
Yeah, so actually, a lot of what you folks are saying, and like in the chat also, Shilpi, what you were saying is making me kind of wonder about one more question. So we're already saying, like, for some of the clear cases, also, there is so much kind of navigation of different laws, ways to get around. Like, for example, what Parth said at the beginning, like, what happens if you just have to show up in the Washington court, for example, or wherever else, right? And this is making me think if this is the case for some of the easier, well, I don't want to say easier, but the more longer lasting pieces, such as of the life cycle, such as data access, data storage, Gen AI models and how they use, and Gen AI agents. I'm not even talking about building the big model, right? Like maybe like Sarvam will build one for India, and we, maybe things for us to think about are after that. But a lot of Indian tech companies are indeed beginning to look at using Gen AI technology, and some of the guardrails on these are kind of onto the usage, right? Like how you guard your usage. So you might end up using some data to just kind of fine tune, to do some retrieval, to do whatever else, and you might end up showing it back. So how do you feel about this new wave of AI in terms of life cycle and technology that is coming about, and is it exposing us to even more areas of open-ended law and regulatory clarity, where we don't know what will happen if such a case happens with Gen AI technology, where you have some core data that you shouldn't have been giving away, it should have just been used internally by your models to do better, is actually somehow being leaked or something of this sort. So would love to hear your thoughts, whoever wants to pick it up. By the way, this is also something of curiosity for me.
So at a first principles level, two answers to your question, Rishita. One, definitely, and courts in India are already at the, where it's at, right? Where a lot of these debates are being actively had, particularly in the context of Gen AI and copyright. We're stretching the limits of our copyright law, and we're calling for active amendments so that it's updated to accommodate leading edge technology. But to your second question about data leakage and core data sort of seeping into Gen AI models for purposes other than originally intended, that brings me back to why strong first principles in your statute are absolutely critical. So when we think about this hypothetical that you've raised, the first principle that comes to mind is data minimization, proportionality, and purpose limitation, sorry, before anything else. When you consent to a particular form of data processing, or when you visit a website and you accept a cookies notice, you are more often than not able to choose the purposes for which you're giving data and what types of data you're giving away. Anything beyond that purpose puts the person processing that data in breach and gives you absolute right to take that to court or to enforce that in any other way you see fit. So thankfully, we have that in the Indian law. It's a fantastically first principles based legislation, which sort of gives me a little bit of confidence that it will endure in the face of technology that's coming up.
Shilpi, you wanted to say something?
So adding on to Mansa, I think I was going to the cookie example, Mansa, when I was hearing the question from Rishita. Earlier, we were only given an option, accept cookies, and now there is like a menu which comes with every permission. Every time you're joining a meeting, you're opening a website, it gives you a pop-up. We are tracking this. Are you okay? Do you want to enable location? All of these are coming now because the laws are mandating the organizations, the applications to have that. Now, one of the other thing that I want to say, Rishita, is what is the most important here in terms of data protection. Let's say when AI agents are coming to just use data and accidentally leaking the wrong kind of a data. I think data classification is must have at the creation state itself. As soon as the data is entering the system, it should be classified then and there. And that is when done right, because when the application will be developed, it will be knowing which data it has access to and which data it cannot access. And that happens even today. Like when we use ChatGPT, if I'm using the work version versus web version, the files that it has access to are very, very different files. So that is, if the data classification is done right, the accidental breach that you spoke about can be avoided.
And just one follow up, I guess. How much of all of this relies on verifiability? Because as you know, even for copyright and all of this, it is indeed, you know, there may be firms, let's say, in the world who are beginning to take slight advantage of the fact that some of this is not very verifiable of what was actually used, given that, we're in this interesting new territory where something may have been used to draw from, but, for example, this recent artistic creativity case that happened with, people saying you can't
Ghibli art.
exactly use this for style. Like, how much of it is coming down to verifiability, claims, strength of how sure can you be about did you use my data or not?
It's a gray area. There's no sure, I think, verifiability. There are laws and checks which are coming now for it. For example, if you are using AI now, systems are asking you to just confirm that did I use AI for something, and that's then gives them the option to verify the data. But it is a gray, I think, area which is in right now development is what I would say. There are checks and bound around it, but
Yeah,
I don't think that they are so as solid as for some of the other scenarios.
right. Makes a lot of sense.
I would like to just add on to the query put
Yeah,
forth. There's a famous case going on in Supreme Court of India, which is between the ANI News Reporting Agency and the ChatGPT, where the ANI is claiming that ChatGPT used the news articles to train their models. Now, the argument put forth by ChatGPT is that we have web crawlers in our system. Now, web crawlers does not know where to stop and where to start. When they are roaming around in the online system, there is no specific thing which can stop them. So anything which is practically available online will be used by web crawlers of ChatGPT. That's what they
Yeah.
have been arguing. Now, why they have been arguing this? Because there's no clarity in Indian laws which talks about how web crawlers should behave. And that's what they are using it for their advantage. So
yeah,
this is
yeah.
some of the practical scenarios.
There
But
can be a very interesting debate done on that, Swar, because web crawler, if something is there already publicly available, how can you say that the crawler could not have access it?
I think that is what I've seen on from the tech side also debates on like now using web page metadata to kind of say that hey, this is okay for a human but not for
Correct, yeah.
inferring on and so on. But I do agree and appreciate that these are some of the very challenging gray areas, and it's useful, I guess, for an audience like this that helps other tech companies navigate law to kind of at least be thinking about where the big gray areas are. I actually missed the fact that in Q&A also we have a couple questions. So, since we have most of you on, and thanks for being generous with time, Mansa, I think there's one for you, which says, how should companies operationalize the right to be forgotten or data portability in complex distributed data infrastructure?
Data portability is a bit more flexible because it's not a law that is mentioned specifically in the DPDP Act. So if I were advising your organization, I would say um, sort of do it at a best efforts basis, but strive to live up to a standard that is on par with the GDPR or sort of other global regulation. And what was the other part of the question, Rishita?
The right to be forgotten, I guess. Like, how do you operationalize? How should companies operationalize the right to be forgotten?
I'm afraid I'm not the best person to answer this question, but from a technical perspective, I would be equally curious to hear how one could
Can
operationalize the
I?
right to be forgotten. If Shilpi, Rishita, or Kavan, you guys want to go in.
Yeah, actually, why don't Shilpi, if you want to go at it, because I know that you
No,
had a
Rishita, please go ahead.
I was going to say the right to be forgotten, at least in the very Gen AI modeling space, that even in production models is very tricky, very, very tricky. I come from having tried to work around this very recently. And I will tell you the more practical ways in which people are treating this is that you do a bunch of de identification rounds on your data before you use it anywhere. And that is not exactly the right to be forgotten, but it's kind of giving you guarantees on using only the data that is not specific. So generally GDPR or somebody else, where GDPR is the more probably the one that's been longest around for the right to be forgotten from a practical point of view. And if somebody files a form, I think basically they're filing for their information to be removed from wherever you have it. And so in more more the places where you can keep it not even that person's information and just a summarized or a view of it, there's lesser such areas to remove from. And that's one way in which, at least in the AI modeling space, that's a common way in which large providers are dealing with it. Shilpi, did you want to add something there?
No, I think you have covered it, Rishita.
So I also see one for me in the Q&A one,
Yeah.
and for um, everyone to hear, I'll kind of say the question out loud. This is saying something like, for deploying large-scale AI solutions in regulated sectors like healthcare, how do I see the evolving legal landscape, cross-border data flow, and so on? And actually, this is a very interesting question, and I think like this speaks to my world a lot. There, indeed, actually, if you see internationally, the regulatory favorability for doing large-scale AI solutions is very different. So, for example, US and healthcare is heavily regulated. To Kavan's earlier point, these are all layered, right? So, like healthcare alone will be regulated in a certain way. The business model of healthcare in the US is very different from India. People almost never pay out of pocket because you have insurers paying for them, and so you have very different incentives in litigation, legal liabilities, all of this in terms of who will go after whom. And for that reason, in US, the entire flavor of what you can do, what you can even try with AI solutions in healthcare is heavily, even with AI agents and everybody wanting to do that, it's in very specific areas where the liability is limited to, let's say, research for a clinician in the back office, or for nurses to send out emails to people in bulk or something like this, not in clinical decision support. But if you instead look at a place like Kenya, and there are some health systems in Kenya which are kind of, they have multiple clinics over the whole country and all of this, so they have enough data of their own, and their Kenya regulations are very favorable for them to kind of improve the standard of care, because they do not have enough doctors of a certain quality spread all over their area. And so there, what they have already been able to operationalize is, every time in their system when a doctor puts in some let's say recommendation for a patient during the visit, they're able to send some de-identified version still, but to GPT-4o directly, and have some diagnosis related, like red, yellow, green kind of, broad stroke, were you good or not kind of a thing, already come out and be told to the patient and the doctor during the visit. This is unimaginable in terms of when US will get to such a state from a regulatory point of view. And I think India has a chance there, and it's being discussed actively, I think, in healthcare across the board, because we have some systems like Apollo that are very mature on the health scale maturity of tech. So, there are people like that who are thinking about where does India regulation lie, what can safely yet innovatively be handled and done. So it's again in that gray area and have to navigate a lot, but it is indeed true across many case studies that it's very different across various borders. Um, I see that we had something. Oh, I guess Shilpi, you presented the Gartner risk management here. Did you want to say that, and then we can have some closing comments?
Yeah. So I just shared it for everyone's reference, how everyone is prioritizing the data governance and risk management compliance on priority right now. And this was a recent Gartner article that I found. But I think we can have data without information, but we cannot have information without data, right? So data is paramount. And the more data we are producing, the more the systems are taking, and the control is with the system. So what we need is the awareness about data protection, technically the knowledge of different laws, the awareness on the cybersecurity to make it easy to save our data, to still continue with usability and be safe. So it's not an option, but it's like really a very crucial necessity to know about all these things and get awareness.
Makes a lot of sense. I also just realized that, Parth, I told you I'll come back to your question for Kavan, and we didn't. We'll do that and then go to closing comments. I see you're still here. So, Kavan, the question for you, along with hope you're doing good, and he asked that here too. So please do address that part of it. Was how do you ensure that your clients, like banks and financial firms, comply to your request to maintain confidentiality of your client data, let's say a loan applicant's data or something like this?
See, Parth, quickly, I'll answer this. See, primarily, my clients are already regulated entities. They are governing under more stringent laws than me. So what we do is we take the consent draft and we share it with them that these are my consent, these are the agreement between us, these are the RBI regulations, these are the regulations applicable to us. Kindly do let us know whenever you are disclosing the information of my client. Generally, everything is API driven, and once the data is entered into bank CLM system, it is then going in a pure RBI's regulatory mode. They'll keep for 7 years or till the time when the loan life cycle is completed. So that is a part, but generally banks do not share the data to anybody unless it is regulated under any other law, like bureaus. Yeah, so they are mandated by the SECRA Act to disclose certain information to a credit rating agency. So that is, if the regulation is there, then of course my agreement or my understanding with the bank will not hold that appropriate when there are regulations sitting on my agreement.
Makes sense. I know we are kind of past time. I know, Shilpi, you had to run. We would love to thank you for being here, for all the valuable comments. And, Witslaws put up a very good panel with complimentary inputs from everyone here. So it was critical for each one of you to be here. Thank you so much. Thanks for
Yeah.
your time.
Thank you so much, Rishita and Vidlaw. I think this is the need of RB. We should have more of such sessions. There's a lot to go into the details.
I fully agree. So just before, so Shilpi, feel free to drop off. I know you had to run. Before everybody else drops off, just on a closing note, I wanted to kind of bring all of our discussions into perspective and ask each one of you about, if India wants to lead as this global data infrastructure hub, which is where we're heading, what's the one thing, whether it's legal, regulatory, contractual, technical, that you believe must change in the next 12 months or must be like reinforced or something like this? And kind of an offshoot to that question is, how can folks like the folks we have in the audience here contribute towards this? Like, what would help to bring their valuable information as they work with different firms back into this sort of an influence process? Why don't we start with Kavan and then we'll go around?
See, I simply say that we have to develop a habit of reading everything, because we don't know how our data is being used and where it is being used. We just simply say I accept and we move on, and later we don't know. So that from a people perspective, it is very important to read something, that what you are stepping into. It is not just because you want services, you keep sharing your every data, then app continuously every 15 minutes enable your microphone and secretly capture your pictures, and you are not aware about that. So that should not happen in this case. So be attentive uh, to the conditions and document first. That is the foremost. Then everything else, people will figure it out on their own, because they will understand the risk and what they are sharing the data with the third party.
It's so funny that you say that, because I can totally see that in myself. Like for work, I will read 6 pages, but when somebody says, "Do you accept because you have to do this next thing?" I'm like, "I accept." Let's move on. So makes a lot of sense. Very good advice. Swar, maybe do you want to go next?
Yes. So I will have a perspective of an at a government level and citizen or an individual level. See, government of India is making lots of effort in terms of owning the Indian data. Now, this is something which is a proactive approach by government of India by setting up data centers, GPUs, and so incentivizing GPUs and data infrastructures. This is the one of the proactive approach, as in the Indian government wants to have an we first as an approach. Any public infrastructure that is being developed in India should be owned by government of India. That says something which is a government of India perspective. That is one of the perspective that our government is looking at to handle such kind of disputes. Coming to an individual level, I believe, as Kavan rightly said, we need to focus and analyze before using any kind of technological solutions, whether it is an AI model, ChatGPT or Gemini. As you, Rishita, also rightly said, we have these tendencies. I believe all our colleagues have these tendencies, including me as well. We always accept and move forward. So this is something we need to challenge upon and we need to think upon as in how we should move forward. Say for an example, there's an important concept of consent in DPDP Act. Now, when a data is being stored with the consent, you need to focus for what time that consent is being given. So this consent is very much important when it comes to storage of data. So this is something which individuals should think on.
Yeah, I think that's very true, and I think from at least from tech people, like from my perspective, if I want to compare and contrast, it becomes like so tempting to just be like, okay, let's go for it. But that makes a lot of sense. I know, Shilpi, you also left something in there about cross-border data transfer laws. I know, I guess Shilpi dropped, but I do think that may be something that's coming up, and kind of we have some outside in pressure coming there as well. Mansa, thoughts there on in terms of either that or anything else that you think is critical in the next 12 months, let's say?
Definitely cross-border data transfers, but I will, like Swar did, answer this question in two parts. One, my wish list for what I would like from the government is that we move fast to create certainty, to bring the DPDP law into effect and to finalize the rules, because being in a state of limbo, which India's privacy law has been for the last 5 odd years, it's very challenging on a daily basis for organizations. However, at the institutional level and for all of us professionals, and this is something I'm curious about as well, is what is the extent of creativity you can have within the confines of the law.
One is, of course, sort of thinking through or reading through all the documents that come to you, but also there's a lack of other legal bases of processing other than consent. How do you sort of structure this in a way that causes least friction for your consumer? One thing which I know we discussed off async over WhatsApp as speakers is are data centers or subsea cables data processors, or are they just infrastructure conduits? And I know that the definition of processing in the law is what it is, and it will likely be a processor. But how can you creatively bring in bespoke liability provisions in your contracts to sort of move things along, or to have sort of a business friendly way of doing things?
Yeah, I was just thinking about it. That is one topic that I was kind of excited about when we were discussing there. But, we had so many interesting topics here. So I'm glad that we got into many of them, at least at a level where everybody's hopefully thinking and excited about it. I am at like 6 a.m. my time now already. So, hopefully everybody else who's much more, at a good time of the day is more excited about this. And we can have many such more conversations in the future. I really appreciate with Law setting this up. I think techno- uh, today's technology state is one where we need technologists, lawyers, all the other fields, creative artists, everybody to kind of talk more across the borders rather than within themselves when solutioning and when trying to think of problems. So, really appreciate it. Really appreciate all of you taking the time. Any closing comments? Otherwise, would love to thank the audience as well for being here, and we can stop here.
Thanks, everyone. And thanks to the WithLaw team and to Rishita. This was absolutely fantastic.
Thank you.
Thank you so much, everyone, for taking time to make this initiative successful. I see lots of versions of vision or versions of understanding regarding how data should flow is being discussed, and I'm thankful to all of you.
It was really very insightful and energizing session. It was really very eye-opening. It highlighted the importance of understanding and intricacies of data dispute. It also showed that it is how much crucial to navigate them very effectively. Overall, it was a very valuable session that deepened our understanding of critical intersection between the technologies and legal framework in data management and digital infrastructure. On behalf of Witlaw, I would extend my very heartful thanks to all our esteemed speakers. Your insights have helped very much the legal challenges tied to the data infrastructure and offered a very clear sense of how organization can anticipate, prepare, and lead in this complex domain. To our moderator, Ms. Rishida, thank you very much for leading this discussion with such a expertise and thoughtfulness. You really brought out the best in each speaker and helped them connect the dots for all of us listening in this webinar during the webinar. I would also like to extend a very special thank you to the supporters, Digital Infrastructure Provider Association, for the commitment to fostering dialogue and around the resilient digital system. And finally, to all our attendees, thank you very much. Your participation and question added a real depth to our today's webinar. We hope you are leaving with actionable insights and renewed perspective on this legal dimension of digital infrastructure. Before we wrap up, just few minutes more, I would like you to mark your calendars for our next session. That will be on 21st of June with the webinar titled as Data as the Catalyst for ESG Transformation, the Legal, Ethical and the Strategic Implication. The registration link is available in Q&A, and also the more detail to the webinar will be provided in our WhatsApp group. The link to WhatsApp group is also provided in our Q&A. Stay connected with us on our WhatsApp for more upcoming sessions and legal updates, and also for more networking opportunities. The recording for today's webinar will be uploaded on our YouTube channel, and the link will be shared in the WhatsApp group shortly. Thank you once again and have a wonderful evening.